Monica, for your introduction. I'm so excited to be here to share my knowledge and probably a couple of stories with you. I'm just very thrilled that we have this platform that Monica actually provided to all investors to learn more about family law. So today it's called California Family Law 101. I just want everybody to know, there's a lot of content about family law. So we're going to touch upon the surface of it to provide you a basic understanding of California family law. And Monica just introduced me. My name is Helen Wong. I am working at MTSA, Morgan Tadago, Sikahodriv, and Azalino. We are a family law firm in San Jose. We do 100% family law. We're actually one of the biggest family law in the Bay Area. We have more than 10 attorneys and 4 partners working on all different kinds of family law cases, including child custody issues, support issue, general divorce, property division, and I'm going to touch upon a lot of these areas today. So just like I briefly said, we're going to talk about a little bit of the basic of a family law, so you have a basic understanding. First question, what we talk about when we talk about family law. So when people talking to you about family law, what come into your mind? The first few things come into mind. What are they? So usually I would say there are 3 big categories of family law. There's custody visitation, financial division, and domestic and intimate partner violence. Today we're gonna talk mainly about financial division. If we have a little bit more time, we'll talk a little bit about custody and visitation. Domestic and intimate partner violence is something that's pretty prevalent these days. If you have any questions about that, we can definitely discuss that later. And there are some other small sections of family law that I'm not touching upon here, like adoptions and so forth. Our firm doesn't practice those. I just want everybody to know that. Okay, so today, 3 big items, and we're going to focus on the first 2. Basic rules for property division and why you might need a premarital agreement. We call it a prenup usually. These 2 kind of go hand in hand. Once I explain basic rules of property division, you will be able to just use what you just learned to apply to the prenup, so you will have a better understanding. And like I said, if we have time, we'll talk about custody concept and dissolution proceeding in California. So first, financial division. I don't know how many people heard of this. This is very, very famous. California is a community property state. There are only a few community property state in California, in the United States, California being one of them. There's Washington. There's most of them are all on the coast, on the west coast. There's Washington, there's Oregon, right? There's California. What does it mean though? Community property state. What does that mean? It has this presumption embedded, which is all assets acquired by a married couple during the marriage are presumed to be owned equally upon divorce. Okay, so I'm an attorney, so I look at the words very carefully. When you look at this, I think a lot of things are very easy to understand. It's self-explanatory, but what does during the marriage means? We're going to talk about exception just in a second. So during marriage actually means date of marriage, which is very easy to understand, then 2, date of separation. It's not date of divorce, okay? It's not date of divorce. So what is date of separation then? Date of separation is the date when you intend to have divorce. You believe there's a final breakdown of marriage and you want to get a divorce. But if you're just thinking about it yourself, you never told the other side, does it matter? It does not matter, right? So there has to be some action that carries out this intent. I'll give you an example. Maybe husband decided that he wanted a divorce and he moves out. And when he moves out, he told wife, I can't stand this. I can't live with you anymore. I think our marriage is over. So that is clear. There's an intent, and then the action is to move out. And sometimes it's not really that clear cut. Sometimes people will still live under one roof, especially given how expensive housing is in the Bay Area. Then one side might just tell the other side, hey, I want a divorce. So there's an intent, there's an action to tell the other side that he or she wants a divorce. And sometimes it's even more, aggressive than that, I guess. Someone can hire an attorney and file a petition for divorce with the court. And when the other side gets this paperwork, it's very, very clear that, husband or wife wants to get a divorce. So there's some exception to this presumption. Gift, inheritance, and assets derived from SP means separate property. If you get these during the marriage, then these are actually accepted from the presumption. So what does that mean is, if I'm married with my husband right now, if my parents say, gifted me $1 million right now, and it's very clear from the paperwork that it's gifted to me solely, then this is not included in the community asset. Okay, so I just talked about a lot of words and concept. We're gonna apply those later, but I want you, the takeaway that what I wanted you to have is, there's a period of time that yours is probably not yours, it's your family's. So from the date of marriage to date of separation, what do you earned? For example, the common thing we earned is salary. My salary during marriage is not only my salary, it's also my husband's income. So that's the kind of the spirit of community property. Okay, so then with that in mind, let's look at the three main aspects of a certain asset, because when we're talking about divorce, we're talking about dividing asset, right? There are three aspects. One is characterization, the two is value, and then three is disposition. What that means is we need to know whether an asset is actually separate property or a community property, or maybe a mix. So which means some part of it is community, some part of it is separate asset. Then once we determine the character of an asset, we can look at the value of the asset, which usually means the fair market value of an asset. And then we talk about how to divide it, right? Who gets the asset? A very simple example is house, okay, where all the investors here. So if you have a house, whether that house is separate or community or even mixed, has a direct impact on who gets the asset. So for example, maybe you, let's say the husband and wife married first, and then they purchased a house. They put down the down payment with their own savings earned during marriage, okay, that occurred by having the salaries putting into the deposit the account. So then you use the money in that deposit account to pay down payment. And then you have a mortgage and you pay the mortgage with the salary that you earn. Is that a separate property or is that a community property? That's an entirely community property, right? Because they get married first and then they buy this house. When they buy this house, they use the money that they earned during marriage, which is community asset, and then they pay mortgage with their salary, which is also community asset. So this is just one of the examples. And another very common thing is, I've seen this a lot in a lot of cases. You guys got married and one of you wanted to buy a house, and you say, okay, we need a house to live in, we want to have kids, you know, we want to have a lot of different things, so let's buy a house. And once when you buy this house, you don't have the down payment because it's a large sum of money, and one of the couple's parents say, well, we can support you on that, and they put down the down payment, right? And then the couple pays for mortgage. Is that house a community property or separate property? Okay, I didn't give you all the facts. It can be a little bit murky, but actually that can be a mix. Very likely can be a mix. And it depends on which side you are on. You can make different arguments. It could be actually a mix, or you can make the argument that this is a gift from the parents to the couple, and then that becomes total community. But if this is just a gift to their own son or daughter who paid the down payment, then it can be argued as this person's separate property because it's a gift to this, you know, son or daughter. So it really depends on the facts, right? But what I'm trying to say is there could be all different kinds of character to one asset. And then when it comes to value, usually, you know, if it's house, we hire an appraiser to do appraisal. That's usually how it's done. If it's like just a bank account, it's very clear, right? The face value of the cash is the value of the asset. And then disposition is who gets the asset. You know, we usually talk about houses, like let's use house as another example. If we have a house, who gets the house? If, you know, because house is not something, it's not an account, you can just literally take the asset out and then split it in half. A house disposition is usually either one side gets it or nobody gets it, it gets sold, right? Or maybe sometimes there's something we call deferred sale, like, you know, one side will hold the house for a period of time, then sell it. So that's how usually it gets divided. And there's child support and spousal support as well. This is a little bit counterintuitive because usually we think that these are like probably custody issue. No, there are financial issues. So child support and spousal support are calculated in different ways. Child support, there's a guideline in California, and it's primarily based on each side's income and the income disparity between two parties. There's a formula. I'm not going to go into detail about this, but I wanted you to know child support is a right from the child to be supported. It's not from either party. It's this child's right to be supported. So it's mandatory, it's guideline, it's formulated in a way to pump up a number for you, so you pay this number. This is one thing that's absolutely like non-negotiable in court. If you have a child and who needs to be supported, if you have a child who spend more time with the other side than with you, and then you have higher income, then it's a no-brainer. You just have to pay it. Spousal support is a little bit complicated than that. It depends on a lot of factors. There's like about 10 or more factors, and I'm not going to go into details about them, but I wanted you to know it's really about one side's need to be supported, and also it's about the length of the marriage, and if there's any criminal records, if there's any domestic violence. So it's an element basis analysis that we need to look deeply and closely to make a determination. And there are also two types of spousal support, but I'm not going to go into detail, like I said here. There's long-term and there's temporary, and it depends on which phase of the divorce case that you are in. You can be subject to different type of spousal support. So now, okay, let's talk about prenup, which is premarital agreement. Let's use what we just learned about financial division in California to think about this matter, because it's very, very important for us to understand. First, what does it do? What does it do? I think most people know this. It's a divorce insurance. It's like, you know, when we get a car, right? When we get, you know, even just like a house, we want to purchase insurance on it because one day something might happen to it. It's the same thing with the divorce, with the marriage. In case one day we get divorced, we want to know what we can do to limit the conflict regarding the financial side. So which period needs the insurance the most? Let's think about it. What I just said is there's California presumption of community property, and it starts with date of marriage and it ends with date of separation. What about before marriage and after date of separation? There's no presumption. Then yours is yours, right? This makes perfect sense. My salary before my marriage should be mine. Like, it's none of my, you know, husband's business. And if after separation, I already told my husband that I want a divorce, then you don't get a piece of it. It's very easy to understand. So which period needs the insurance most? It's from date of marriage to date of separation, right? Because that's the portion that we need, that has the presumption, and we need the protection. So therefore, the biggest function of prenup is actually preemptively rebut the community property presumption. So we are trying to target and focus on this period of time. It doesn't mean that you cannot put it in the prenup that something is earned before marriage, or, you know, this is entirely mine and I just wanted it to be recognized. That is fine. You can put that in the prenup. However, without a prenup, that's still true, right? That's still true. If you have a clear record, if you have a bank statement 1 month before marriage, date of marriage, showing in your bank you had $2 million, does it matter you don't have a prenup? It does not, because at the end of the day, when you get married, if you present that bank statement, it is proof that you had that much cash in your account before you get married. So there's no dispute about that. It's very clear. That's why I'm saying the biggest function is not to actually secure your asset before marriage, which is a concept that a lot of people get confused about, because I get this question a lot when people come to me and be like, what about all these assets I earned before marriage? What about all these like houses I acquired before marriage? That's all good, because if you have documentation to prove you have these assets before marriage, you actually do not need a prenup to protect it. You get what I'm saying? But if your purpose is to limit the creation of community property during marriage, that's when you really need a prenup. So we see a lot of prenup that says this contract provides that no community asset will be created during marriage, which means during marriage, your salary is still yours. My salary is still mine. So the biggest, function of that is to make it super clean that during the marriage, there's no mix, right, of asset, and there's no character issue. And you don't have to go extreme, of course. I'm talking about 100% community property during marriage versus no creation of community property during marriage. You can be in the between. You can say, I want, like all the salaries can be community property. Everything else, all the other income is our own income. That is fine too. So it really depends on how you want to structure your prenup. But if you do not want to rebut this presumption, you want to share your asset during your and then with the exception, right, that the gift, inheritance, those by default are separate property, even if it's during marriage. But if you want to share your salary or other income during marriage with the other side, there's no need for a prenup. If you do not want to share it to an extent, then you need a prenup to put that in writing to rebut this presumption. So what you can do to protect your separate property during marriage if you do not want a prenup, it's very, very easy. It's easy and hard at the same time, I want to say. What do? You keep records, and you keep records clean. What does that mean? So if I have a separate bank account, I've been putting money into it, and now I'm getting married, do not mix funds from this account with all the other community accounts. What does that mean? Do not put your salary in this account. Do not, transfer money out of this account to put it into other account that could have community asset. So you keep this account intact. Everything is your separate. You do not take funds out. You do not take funds in. If you take any funds, it has to be in the same character. So it has to be either you can move money from one separate account to another separate account, but do not mix separate and community. But like for me, I always tell my clients, do not even just move. Do not move any asset unless there's big asset that needs to come in. For example, if I have a separate property account during marriage, my mom gifted me $1 million. I want to put in this account, which is fine, but do not mix other character with it, because at the end of the day, what we divorce attorneys do to find out the character of a certain asset when it's mixed, right? We know it's mixed, but we don't know how much is separate property, how much is community property. What do? We do tracing. Tracing is just like it sounds. Tracing is a tool and mechanism to go back in time and to go back in years to find out where this asset come from. Because at the end of the day, what matters for character? Source funds matter for character, where the money comes from. So if the money comes from a separate property, then it's separate property, right? Then you need to go back in time and see, okay, if this money is really separate property or community. I give you one example. This is one of the biggest cases we've handled in the last few years. We had a client who received gifts from his mother 20 years ago when he was actually just a baby. When he was 6 months old, his mom gifted some shares to him. So basically she did account for him and put these shares under that account. And guess what shares she put? Like a lot of Microsoft, a lot of other very prominent shares these days. And 20 years later, guess what? Those shares have exploded, right? Like, so we're talking about a few $1,000s. Now, 20 years later, it becomes like tens of millions of dollars. Then the problem is our client during marriage, of course, they didn't have a prenup, and during marriage, he didn't really care, right? And that's the thing, when you are like in a marriage, usually you want to share things with the other side, and you don't necessarily go and learn family law and try to understand how I protect my asset if we get divorced. So he did mix a lot of his salary and other funds into this brokerage account, and he bought other asset and he moved things around. It was very messy. He did day trading, right? So now 20 years later, we want to prove the majority of the asset in his account is his separate property because that was what his mother gifted him when he was 6 months old. Guess how that turned out? It was not good, right? Like we have to go back in time 20 years from now to trace back every single transaction to prove these go back in time and actually go back to this one transaction that his mom did for him 20 years ago. So that is tracing. It's a very extreme example, but that is exactly what we do when we need to find out how much community assets versus separate assets in one account or in one asset. That is very challenging. That is challenging in the fact that one, you have to spend a lot of attorney's fees, right? And usually we hire accountants to do this too. So you have to spend money on accountants too. And then it is a lot of work, a lot of paperwork. It's very hard to piece everything together if you do not keep good records. And my client, who is an engineer here, who is very smart in keeping records, so he actually had 20 years of records, which is amazing. Every single bank account, bank account statements and all the notices, right? So this is what I mean by keep records and keep records clean. You absolutely want to collect every like bank statements, if it's an account or if it's some other asset, whatever proof that you want to collect to show there's a trace of the asset, how it grown from this amount to this amount. And then you want to keep the records clean. So at the end of the day, no attorney or no forensic accountant need to come in and do all the accounting for you. It is not easy, but if you want to have this insurance without prenup, you should do it. If you want a prenup, then of course you can put all these in the prenup just to double confirm these are the assets that I have before marriage. And there's no question about it at the end of the day, whether this asset is actually my separate property before marriage or not. Okay, so the next thing I wanted to say is what can be included and what cannot be included. After I talk about this, I also want to talk about requirements of premarital agreement because it's very, very specific. So what can be included is financial division should the parties get divorced. It's very simple, right? It's basically money and asset. But what cannot be included is custody and child support. So you cannot put the prenup that, oh, if we ever have a child, then we want this child to be with you 100% of the time. You will have the custody and then I will pay this amount of support. This is illegal to put in the prenup. Even if you put in the prenup, at the end of the day, this will be deemed as invalid because go back to what I just said about child support. Child support is the right of a child to be supported. Before this child is born, you don't even know. You don't know whether this child would need how much money. And it also depends on, it's ongoing. It depends on this child's need at different age, right? At 6 months old versus at 6 years old versus 16-year-old. It's just very different. And the custody as well, right? And I will also want to just mention custody and child support in family law is always modifiable. It means if some new circumstances come along, you can always modify that. You can always ask for new support number. You can always change custody if there's a scenario that warrants that change. So then we talk about requirements. Why do we talk about that? I just want a lot of people to know prenup is an area of family law that's being contested and disputed and challenged a lot. Why is that? And even sometimes the side who wanted to have prenup to begin with will end up actually challenging the prenup. I don't know how many of you know stand-up comedian Ali Wong. I don't know if you watched her special on Netflix before. She did mention she was kind of like, you know, not like forced, but she didn't want a prenup, but her husband wants a prenup when they got married because she was nobody. She was just an undergrad, graduated, and her husband at that time was already a Harvard Business School graduate and with a really wealthy family background. So his family, of course, wanted a prenup, and she agreed to it. And lo and behold, now she earns way, way, way more than her husband. This type of scenario doesn't happen all the time, but it does happen. And when that happens, sometimes the side who wanted a prenup to begin with will end up challenging prenup, trying to find loophole in prenup and say this is not a valid agreement. Why? Because if the prenup is not valid, then they can share the asset during marriage, right? And all that asset, all the money the other side earned during the marriage will be subject to division. That's why a lot of people challenge it. Just because it's highly contested. The law has very specific requirement for the prenup. It is a contract. How this contract is examined, formed, structured, is directly linked to whether it's valid or not. And if it's not valid, then the presumption holds, right? If it's valid, then you have a contract that protects asset during marriage. So what requirements are we talking about? First, there needs to be 7 days waiting period after the premarital agreement is finalized before signing. What does that mean? So usually how it works is one side has an attorney, and the attorney will draft in a prenup, and then it will send to the other side, and the other side will take a look and get back and, you know, maybe revise a little bit. So there will be a process of that. But a lot of people, this is the regular proceeding, but before this requirement comes out, which was a couple of years ago, before that, actually a lot of spouses were kind of forced into signing this the day on the wedding day or even the day before. What it happens is usually like, hey, we're getting married. If you don't sign this, I'm not going to marry you, right? And the other side is desperate to marry this person, and they would just sign. And at the end of the day, it creates a lot of the issue because I will talk about it because, you know, it does not here, you have to sign it voluntarily and without fraud, intimidation, duress, or coercion. It is very easy to understand, right? This is true for all contracts, not just a prenup. You should enter into an agreement voluntarily. And if you do not do that, then that becomes a base to challenge prenup. Another thing is you must provide opportunity to the other side to obtain independent counsel, because whether you have a counsel or not, whether somebody can take a look at this agreement and tell you whether this is valid or not, or what it means, what are you signing away, what are your rights, you don't really have a full understanding of it. And without a full understanding and you sign it, you become another aspect to challenge the prenup. The 7-day waiting period, I just want to have one last thing to say about that. It is after this agreement is finalized. We're not talking about all the other, you know, negotiation or back and forth on revision of languages. We're talking about after it's finalized, the other side, actually both the side, of course, but especially the one who received the agreement needs 7 days to just think about it before signing. If it's less than 7 days, it also will become an area of challenge for prenup in the validity of the prenup. And also, it may not include any clause that demands or punish a spouse for an action or an issue. this particularly speaks to, you know, whether, oh, I wanted you to do this, like I wanted you to, you will put it in the prenup, if you do not do a certain action, then you do not get this amount, or if you, you know, if you have to do this action, then I will punish you by lowering this amount. These are not allowable under the prenup. And then the last one, this is very tricky. It's called cannot be unconscionable. What that means is unreasonably unfair. But what does that mean? What does unreasonably unfair means? It is very murky and vague. It is kind of like a catch-all phrase for the judge to decide if there's anything absolutely outrageous about this agreement that the law didn't spell out, but we all know it's injustice to actually recognize that. Then the court will actually determine that this is not valid. So I just want to give you one example. I just had a case, actually, the wife came in and said that I was, you know, basically forced into signing this. I didn't know there was an existence of a prenup. When my husband asked me before marriage whether you will sign a prenup to protect my asset before marriage, she said, yeah, of course. And she didn't know that prenup actually has provisions to limit the community property during the marriage, right? And she was brought into a law firm that she doesn't know, and she met this attorney on the day of, and also she speaks very little English, and the attorney is hired to give her consultation in Chinese, and she looked at everything, and she was not explained by the attorney everything that's actually included in the contract, in the prenup, and she signed off on it. So this will become a base to challenge prenup. And if this challenge is ruled valid, which means the prenup is not valid, then the presumption will hold, which means the whole divorce will go forward as if there's no prenup. So that's the prenup section. So I will talk a little bit about custody and visitation very briefly. There are two different kind of custody. One is called legal, one is called physical. Either one of them can have different combinations. It can be sole custody to mom, for example, and sole legal custody to mom, and sole legal custody to mom, so physical custody to mom, I'm sorry. And but most commonly we see joint legal and joint physical for both parents. In California, it's very, very rare to have one party to have sole custody all the time, because the public principle, public policy, and backing with a lot of scientific proof and research shows that a child will actually thrive physically or also mentally when she or he has equal access to two parents. Because of that, so the judge is always leaning towards joint custody for both parents. But there's extraordinary circumstances that will warrant sole legal custody, but we're talking about extreme circumstances, like, you know, maybe one side has criminal records and is in jail right now, or the other side is a drug addict, right, has mental health issues, has severe domestic violence issues, and so without all these scenarios presented in a case, most likely the court will have joint legal, joint physical custody for the parents in the end, even if they don't start with that position. And then there will be visitation order. It will be very simple. You've definitely have seen this in your real life. You know, there will be specific timeline as to who, like, you know, for example, dad will drop daughter at which place at what time, and mom will pick up, and who has how much time. That's essentially the visitation order. And then there's something called best interest of the child. You may or may not have heard of it. It is basically a principle that is established to to protect the safety and welfare of that child. So when the court examine a lot of custody issues, they use this as the principle and standard for examine what outcome will be the best for the child. So then a little bit about dissolution proceeding in California. How does it happen? A lot of people ask me, how do I do that? And some of my clients come from China, first generation immigrants. They know in China, you just go to government agency, you actually just obtain this like booklet and it says you're divorced. That's not how it's done in California. I've been trying to explain to a lot of people. So basically you have to go to court. Somebody has to bring a petition. It's called Petition for Dissolution of Marriage. And the side who brings that is called petitioner. And the other side will do a response. And that side will be called respondent. This is not a regular civil case where we have plaintiff and defendant, because ultimately there's really no right or wrong. Like it doesn't really matter who initiated this divorce case. Nobody is defending it, right? Nobody is actually like kind of prosecuting it. So there's only petition and response. And one more thing I want to raise here, because a lot of people get confused. There's no right or wrong usually in California's divorce case. What that means is California is a no-fault state. They don't care whose fault it is that led to this divorce. Sometimes it will have a little bit of impact. I will give you an example, but most of the times it really doesn't matter. You don't have to go to the court and say, hey, court, the reason I'm getting a divorce is because my husband is cheating on me. The court doesn't really care. The court would not punish the other side more just because he is cheating on you. So there's no fault per se. The court doesn't see this as a fault by the other side, even the other side is cheating on you. So that would not play into this divorce. So you would not get an upper hand if the other side is really cheating on you. It does matter sometimes if financial issues is involved. What that means is, for example, if my husband is cheating on me, and he used a lot of community asset, right? The funds in our joint account to, I don't know, to go out and date and, buy gifts to his girlfriend. So that will be an issue. That can be brought up in court if necessary, because it's misuse of community funds, which is a breach of fiduciary duty on his part. I'm not going to go into detail about this, but just because a lot of people ask me, it doesn't matter that my spouse is cheating on me when I go to court. Generally, no. And so and then after the petition and response are filed, and then we have financial disclosures. So each side will do disclosures about their finances and exchange with each other. Why do we do that? The court wanted that to be done because a lot of times in a marriage, there's one spouse that's very actively managing finances. The other side is probably not. Or maybe, yeah, it could be like both of them are very actively managing their finances. But at the end of the day, if we're talking about dividing asset, we at least need to put all the asset on the table, so we all know what assets we're talking about. And if we have those assets all in one basket, then we can divide them. The court doesn't want any ambiguity about what asset is out there or not. If you do not disclose, intentionally not disclose one asset that's actually under your name, you will get in trouble later. So this is why the court wants to do disclosures, because it is procedure to put you under oath to say, these are my asset, or these are the asset that I understand to be in existence. under our names. And it really doesn't matter whether it's your separate property or a community property. The court wanted you to put all asset on the table. And then we started to look at the character of the property, whether it's community or separate. And then this goes to what I just said, right? Then we look at the value, and then we look about how to divide them. And after financial disclosures, usually we enter into settlement phase. A lot of people get confused. They think like attorneys run into the courtroom and then just, trying to pound with a lot of paperwork and try to litigate. That's not the case. We always start with settlement. If we can settle a case, we would never litigate them. However, a lot of cases just cannot be settled, right? Two parties cannot be brought together. You can't, force people to settle. So if that doesn't happen, you can end up in court litigating particular issues. There's also another proceeding called mediation. Sometimes we assist in that as well. What it does is it has this neutral third party. So this party is neutral. But if I'm your attorney, then I'm not neutral, right? I'm only looking after your best interest. So this mediator will sit down with both parties and then look at all different assets and, even custody issues and try to come to an agreement. We've had a lot of successful mediation cases as well. And of course, it takes one type of people, that personality of people, to actually settle. Sometimes you just cannot settle a case. But we've had a lot of cases that actually went to mediation and had successful result. This is absolutely always my preference because it's less confrontational, it's less expensive. It provides an opportunity for the parties to come to an agreement that both of them can be satisfied, not like totally happy with, because negotiation is about compromising. There's never going to be one case you're absolutely thrilled about because you have to give up something to get something. But at the end of the day, mediation actually is less time consuming, less expensive, just puts more control in your hand. And then we will have a partial or final judgment. What that means is a final judgment is a final judgment. Everything is divided, right? Maybe the custody can keep going because, like I said, it's always modifiable, but at least we come to an agreement about the structure of the settlement and how do we just divide the house, how do we divide the accounts, how do we divide retirement funds. Everything is put into an agreement for a final judgment. But sometimes the cases are very complex. They drag on for years for whatever reason. You just cannot reach a final judgment in a short period of time. And at this moment, a lot of clients want a partial judgment, which means termination of marital status. So you can, yes, you don't have to wait until all the divorce case is done to have your marital status terminated. You can actually terminate it in the middle of a divorce. And there are a lot of reasons you want to do that. Maybe one, there's tax issue. You want to file tax by yourself instead of still entangled with the other side. Sometimes there's a need to get remarried, and then you need, single status, right? And sometimes it's just a finality, like it's been dragging on so long for years. I just can't stand it. I don't want to bear with this idea that I'm still married to this person. So you want a termination of status. So that's called partial judgment. And there's also a 6 months rule. I don't know how many people know about this. So the earliest day you can get divorced in California is 6 months and 1 day after you file the petition. Actually, let me rephrase that. It's not one after you file a petition, because after you file a petition, you still have to serve it. So it's after the service of petition. And 6 months and 1 day, some people think like, oh my God, I have to wait so long. But in reality, unless your case is absolutely no contest, okay, we call uncontested divorce case, which means everybody is on the same page about everything. Unless it's that kind of situation, most likely we'll spend 6 months on even just getting petition, response, and financial disclosure ready. So it's not really a very simple and quick route to get resolution. And California court is also very, very backlogged these days after COVID. It's very hard to put something on calendar. This is just something I want to throw out there because a lot of people want to know how long I can get a divorce. The quickest day is 6 months and 1 day, but most likely it will be longer. Okay, this is one last word I have for a lot of clients of mine and also new clients. Divorce is not the end. It's a new start. This is the mentality you should have going into a divorce, because divorce is very emotionally draining. It can be very messy. It can take a toll on you and your family. If you do not have that mentality, like, this is just a process, I just need to go through this and get to the end, it can weigh on you heavily. So I just want to have this word for everybody. Divorce is not the end, it's a new start. If you see divorce this way, you will have an easier time, not entirely better time, I guess, but easier time dealing with your divorce. Okay, so I think that's all. I'm sorry, I talked a lot.
That's very informative, Helen. That's very, very helpful. So we learn a lot, especially, many of us are parents, having the kids maybe getting married, and they do already have like some prior to marriage property. Like, one question from the audience is, if the house bought before marriage, but monthly payment is paid by both parties, so how would it be considered? Is it going to be under the community property after they get married?
It's a very, very good question. There's a lot of different scenarios that, associate with a house. So if the house is bought before marriage, I would assume the down payment is paid by this one, let's say husband, okay? The down payment is paid by husband. And the title is under husband's name, right? And then after you get married, you start to use community funds, right? Which is, you said, paid by both parties to fund this house. So this is where we call, there's a more Mariston, I'm sorry to use all these like legal words, but it's actually a case name. So we use case names to talk about different solutions. So there's a more Mariston analysis associated with this. Basically, we need to get down to a percentage. What is the percentage that the community contributed to the house? And what's the percentage of the separate property contributed to the house? And the community will get benefit, definitely, from this house for the appreciation it actually has by ratio of getting the contribution into the house. I don't know if that makes sense to you. And also another thing is very important, which is title. I didn't talk about title in my presentation. Does it matter sometimes? It does not, but sometimes it does. Everything it depends in law. So when we're talking about a bank account, if, let's say, I have my own account that I opened before marriage, but then after marriage, I still deposit my salary into my own account. Okay, so on the account, only my name is on there. My husband's name is not on there. How do we divide this? How do we see the character of this account? Is it community or it's separate? Right? In other words, does the title of a bank account control? The answer is no. Okay, the answer is we look at the source fund. So if there's any money in my account at the date of marriage, that's my separate property, but everything else that I deposited with my salary into this account after marriage is community asset, even that account only has my name. Here for the house, it's a little bit different. That's why I said it depends, because when you have in a house, and you, for example, you bought the house before marriage and your name is only on the house. And however, after you get married, and I see this a lot, okay, you change the title of the house. So it was your sole and separate property as an unmarried man, and now maybe you put both of your name on there as the joint tenancy with right of survivorship. Then the change of title in that regard can actually make a difference in determine whether it's community and separate. But of course, it doesn't mean it will be entirely community. It really depends. But one argument can be made, since you made that title change, you intended to transmute. This is another word that we use in family law, which means you change the character of the asset. So the character of the one asset doesn't stay forever. It can be changed if you want to change it by written agreement, right? And then one argument can be made by you during the marriage, changing the title from your own separate asset to joint tenant with the right of survivorship. You actually transmuted, you changed the character of that asset to be community property. So that's another thing to take into consideration. But even if you didn't change the title, in your scenario, yes, the community will get a share of this house, just because the community did contributed it to the funds into the mortgage.
Yeah, that's very detailed. Yeah, that's it. Yeah, really appreciate the detailed explanation. And then is the follow-up question. I think is good. It comes from another attendee. Say, how often do you think, especially, we have a Chinese and Asian background, willing to sign the prenup nowadays? We're talking about especially the young generation.
Mm-hmm.
And then there are like three other follow-up questions. If filing tax jointly, how would that impact whether there is a no prenup or we have a prenup when divorce occurs? And then can the prenup or no prenup specify how to divide financial liability like loans, debts, and court judgment?
Okay. So this is hard to say. I think the younger generation is definitely way more willing to accept this idea of having a prenup. However, I don't think we have come to the point where so-called, Westerners, right, when they have this history of having prenup and having independency about their finances. So I think it's still a very hard conversation to be had. I don't think to answer your question, I think it has improved in terms of younger generation, but are they really willing? I don't know. I can say if you want to have that conversation, you should have it early, very early enough. For a lot of law firms, if they want to do any prenup, they want to take on any prenup case, they actually need a lot of time. Like, for example, my firm will have 6 months in advance of your marriage, or wedding, to have this opportunity to do a prenup. And the reason is because there needs to be a lot of back and forth, potentially, right? A lot of back and forth negotiation on the prenup. And you don't want to rush that process. You just don't. And a lot of people this idea can be hard to swallow for some people at the very beginning. But some people will warm up to this idea eventually. So if you have that conversation early on, it can make a difference. And it also depends on the income disparity. If you're talking about someone who's making, I don't know, right, like 60 grand a year versus someone who makes 1 million a year, I think that is going to be very hard to have that conversation. However, another thing I just want to mention, by making this process a little bit easier to accept, you can also put a higher number in the spousal support buyout in the prenup, right? You can say, okay, if we get a divorce, I will give you this money to support you and that should be sufficient for X amount of year. You don't have to write in the contract, but we all know that's a big lump sum money. And with that, maybe we'll provide a little bit more security to the other side. And just to go back to, the other question. So if filing tax jointly, filing tax jointly or not, how would it impact prenup when divorce occurred? So it really does not really have a lot of impact. During the marriage, if you wanted the tax to be really clean, you can put in the prenup that you want to file tax, just separately. But most people, I think, would agree. And if you go to your accountant, filing jointly will save, especially the side who has a lot of asset and income, tremendously, right? Filing jointly. So you might want to take that into account. If you have separate property that's protected by prenup and you file tax return, you get more tax benefit than the other side. There can be also calculation done by accountant to divide that tax liability to make it even. It really depends on how you want to do it. It could be also just waived by the other side. Okay, I'm taking more tax benefit out of this tax return, but I mean, I'm supporting you in this way, right? So it might not really matter. It really depends on how you want to see it. But if your question is, I have a prenup, would it have a direct impact on my ability to file tax? No, you can just file tax jointly or separately. It really depends on how you want to do it. As long as you are a married couple, you can file tax jointly. And how prenup or non-prenup, specify how to divide like loan, debt. Okay, yes. So if you have non-prenup, that will just become part of the regular negotiation and it will be wrapped into the final judgment. And how do you divide that? It really depends on what kind of debt, what kind of loan. So if it's like, student loan, for example, it gets a little bit murky. I don't want to go into detail about that, but that can be different from mortgage. If it's mortgage, then you need to take that into account when we are talking about dividing asset, right? Who wants the house? If that person can actually assume the mortgage. If that's not the option, then sell the house, the mortgage will be paid, right? And then you divide the rest of the sales proceeds. So it really depends on what kind of asset we're talking about. And then if you have prenup, you can put division of loans and debts in that prenup. You can say, okay, these are my own loans. I will assume all responsibility associated with that loan. Or you can put it in there if you want any creation of community property and you only want certain mortgage associated with that responsibility, you can also put it in the prenup. It really depends on how you want to structure it.
Got it. Yeah. So I have another question. Again, I think you might have answered to a certain extent. If the property still has a loan, what will be the value in case of dissolution?
Still has, what be the value in case? Well, like I said, right, how do we do it? So usually we hire an appraiser. And that appraiser, it can be done two ways. One is we can hire a joint appraiser. Each side will pay half of the fee of that appraiser, and then an appraiser will come out with one number, right? And then we just use that one number for one side to buy out of the other side's interest. And then when we do that buyout, the loan will be calculated in. If you want to sell the house, nobody wants the house, or both party wants the house. That's usually what happens if both of you wanted a house and the court cannot make a determination one is more entitled to than the other to get the house, then the house is ordered sold. And once the house is sold, the loan will be automatically paid, right? And then after closing costs, all the different costs, and if there's any reimbursement claim, we get rid of all that, and then what's left can be divided, then we divided them. That's how we do it.
Got it. So we got a question from Ms. Wang. I just want to also mention that Helen is kind enough to offer a 30 minutes free consultation for the people who register for this event today. So if you have a lot of specifics, you could also, save your question in a private consultation, because like cases like this, it seems that like also is very personal. Like this Miss Wang or M Wang, mentioned about like say for the property received as a gift by one spouse during marriage, and then is the property considered 100% community for these two cases? So first, the spouse refinanced without the other spouse on the loan, but they paid a mortgage payment together from a joint account. And then another scenario is the couple refinance with both names on the loan and pay mortgage payment together. So this is the scenario.
This gets a little bit too detailed. So I need a little bit more facts on this. When you say the property received as a gift by one spouse during marriage, are you talking about so it sounds like we're talking about house, right? So you received this house, and so the title is only under one spouse? Is that what it means, like received as gift? If the title is only under one spouse, and then you used it sounds like you've refinanced and it's also only under one spouse's name for loan, and then the mortgage payment together from joint account, this will be another scenario where the community, when I say the community, means husband and wife or the couple, will have a reimbursement claim against this house, right? Because the community used the funds to fund the mortgage, so it has an interest in the house. That needs to be calculated, and then that needs to be backed out. And also, just to make sure, another thing I just want to mention, because I know this group probably is very particularly interested in this, is I said keep records and keep records clean, right? When it comes to gifts, it's particularly true. If you want to give a gift to your grandchildren, your children, make sure it's documented, okay? Don't just send money over and then be done with it and, oh yeah, that's the gift. No, like make sure have documentation everywhere saying this is the gift to who and who solely, right? That will prevent dispute later down the road, whether this gift is really to the parties or to this one person, which is your son or daughter. Because in this scenario right here, a gift by one spouse, that's good. That one spouse should have the credit of having that gift. And then the couple refinance with both names on the loan. This is really good question, because when you refinance and you have both of the name on the loan, it will get the whole scenario messier. So the other side will have a better argument against the house regarding whether the house is community or separate. In the first scenario, because the title is on the house was received as a gift, there should be no ambiguity that the house is a separate property and the community contributed to the mortgage. But the second scenario, it can raise a question of whether the character of the house is community or not. Does that make sense? And in the second scenario, if the title, because if you have two people on the loan, I suspect that the title also changed. And if that's the case, like I said before, right, you potentially actually changed the character of the house. An argument at least can be made to that.
Yes. So we encourage M. Wang to reach out to Helen directly if you have like specific to address, and you can set up a private section. Okay, I have another question. Maybe I think because of the time, we'll answer John's question, and then maybe one or two more questions. Then we can kind of wrap up so that we respect Helen has a number of activities on weekend. So yeah, it's almost like she gave us like a very precious time of 1.5 hours already. So let me start with John's question now. He said, you talked about this earlier, in terms of if we purchase the house after marriage, the down payment come from each of the fund before marriage. Say if the husband put down 100K, the wife put 200K, so the 300K become, will this one 300K become community property, or each of them will get the down payment back before dividing the sales proceeds in case they go separate?
Yes. Okay, so here, one very, very important thing is we need to determine where those 100,000 and 200,000 come from. Okay, if because we're saying we purchased this house after marriage, it can be 10 years after marriage, and these two people already accumulated a lot of funds during this time. Even it's one side put down 100K, it could be the entirety of 100K could be the salary earned in the last 10 years, right? So there are two different scenarios basically. If we're talking about this 10K and 20K to be even under their own name, but also community asset, which means the money they earn during marriage, then it doesn't matter because all of them is community property. So the whole down payment is community property, and then you use community property to pay mortgage. So the whole house is community property. That will be actually pretty easy because when you sell the house or one side wants to buy out the other side, the calculation is very, very simple. However, let's assume this 100K and 200K were actually earned before marriage, right? Or maybe some gift of money from the parents. Then one side put down 100K, the other side put down 200K. So these 300K do not become community property. Even the house becomes, the both of them name gets on the house, because they use the separate property to pay the down payment of a community house. So they need to get reimbursed. We call reimbursement claim. So at the end of the day, wife, after everything else is calculated, let's say the house is sold, right? The whatever cost is paid, loan is paid, closing cost is paid, then wife will get 200K back. Husband will get 100K back. And then the rest after all these deductions, the rest of it, assuming the mortgage is paid by both parties with their salary during the marriage, which means 100%, right? Community, the mortgage is paid 100% community. So with all the reimbursement claim taken out, the rest needs to be divided 50-50. So I'm sorry, I don't know if I'm talking too fast, but if this math makes sense to you.
Yeah. Well, the next question, I think it's a question that many of the attendees would be interested, especially if they have children getting married.
Right.
How much does it cost to prepare a prenup typically, and what affect the cost?
Okay, that's a good question. So in family law, it's almost 100% hourly rate. So we charge by hourly. And what has an impact on the cost? Everything, right? Because it's probably if you have a lot of asset, right? If you are very, very wealthy, which is really good for you, but then we need to write more than a regular prenup, right? We need to sort out all different assets. And if you need more consultation with the attorney to understand more stuff, then that needs to be calculated. But even if we can, and then the reason I'm talking about all this is because there's no way we can actually estimate how much, because we don't know how many hours can be spent on this. And the most portion that's kind of hard to predict is the negotiation. We can send something over, the other side can push back on something, and then we send over. It's like the whole negotiation that can happen for months. So we don't know how much money will ultimately be spent, but it will be charged by hour.
What is the average hourly cost?
we really don't have that. And I'm sorry, because I get it. Yeah, I get that
yeah,
question a
you
lot.
cannot
because there's
provide
no
a
errors.
range on hourly cost. You know, I just need hourly
Oh, yeah,
cost.
yeah, yeah.
I'm not
Hourly
total.
cost, yes. Right. The hourly cost is usually from our firm. It's from around a little bit under 500, so 475, all the way to 325. That's the range. And
So, like,
every law
so-
firm charges also differently.
So like say, pay every month or pay at the end?
Pay every month. Pay every month.
Every month.
We
So
will
like
send you
say
a bill.
475, and you said, actually, is it, did I hear it right? 375 to 475 or 475 to 575? I just want to make sure.
So it's 325.
325?
Yeah, to 475.
Okay, got it. Yeah. Okay. So I got it. So it's still monthly. So
Right.
the lawyer would be kind of negotiating and helping both parties. So we'll go back and forth between the fiancés, you know, like the future husband and wife to be, and try to get a medium ground, right?
Monica, I just want to correct one very, very important thing. If you hire an attorney to do a prenup, this attorney will not help both parties because it will be a conflict.
Oh yeah, so it would be okay. So it would be just the husband or the wife directly, but then the document being prepared, it would be sent. Say if the wife initiated it, it will be, she has the responsibility to send it to the husband and gather his comments, but then it might come back for review, and then the wife, the future wife to be, is going to talk to the lawyer and kind of do the amendment, right?
Right. So ideally, two sides, either side will have their own attorney, because depending on how complex this is. And also, if you recall in my presentation, I talked about when we do prenup, one side or both sides must have the opportunity to seek independent counsel, because it actually has huge liability exposure if the other side doesn't have an attorney, because later down the road, this person can actually come back and claim maybe, oh, I didn't know this, I wasn't informed that, right? So it would be better if the other side have an attorney.
If the
other side does not, if the other side does not, it can still be done, but we will encourage the other side to get one, actually, or at least consult with an attorney.
Yeah, certainly. Yeah, that's a good point. So, say being parents, like say most of us maybe set up living trusts, for the beneficiary to pass on to the children as, the inheritance of asset or properties and all this. And all the trusts only actually name the children as the inherit party, and without, including the spouses. So for asset like this, can it be named separately for the children, not including the spouse? But then, the parents may pass away after they got married. So how would that happen?
Yes, that's a really good question. It actually has no impact, because it is a gift. It's inheritance. If you put all the money in a trust already and then named your children as the beneficiaries of the trust, and even they get married and then you passed away during their marriage, it will only go to them. It will consider as inheritance. The other side would not get a share of this.
So for this particular aspect, do we need to include it in the prenup, or it does not need to be?
If you, like I said, I think the biggest function of the prenup is to limit community property, right? If you do not have that concern, you want to share your asset during marriage, and you are just a little bit concerned about this trust on the side, you actually do not need a prenup, because the trust is the trust that's already established. Even you receive it during marriage, it would not consider to be a community property. However, if you just want to be super cautious. You don't want any ambiguity, and you have a lot of assets actually before you get married, right? Maybe this is your second marriage, or maybe you're like later in your life, you have accumulated a lot of wealth. You want to have it to double confirmed. Yes, you can still do a prenup. But like I said, I think the biggest function of the prenup is to limit the community asset. If the only concern is about gift and inheritance, there's really no need. And if you have a trust, everything is perfectly documented anyway.
Okay, so it would be inheritance or gift would be considered separate asset, regardless before or during the marriage.
Correct, very correct. And of course, like I said, one more time, please keep good records of these gifts and inheritance. If you have a trust, and there's no problem. But if you're just like sending $1 million to your daughter without any at least something in writing, that can be problematic in the future. But in general, if you have good documentation, it's a gift, it's a inheritance, it doesn't matter. You don't have to have a prenup.
Got it. So like say, I think probably this should be the final question for the day. And then we encourage everyone who have a specific question and would like to engage Helen for her service to reach out to Helen directly. The last question is, if investment and retirement bank account have beneficiary to someone other than the spouse, just like say someone, maybe children or maybe grandchildren or whoever, can the spouse still claim the funds? I think you probably addressed it.
Yes, this is a good question. So the beneficiaries of the account are not the title holders of the account. What that means is when the account need to be divided, we only look at who put these funds into the account. The beneficiaries are another step, right? Beneficiaries only come into play when this person actually dies. And we're talking about when this person is still live, right? Like still in existence. So yes, it really does not matter. So if you put your children as beneficiaries, for example, and then now you're going through a divorce, it's still your account, your and your spouse's account. It can only be divided between two of you. It has nothing to do with the beneficiaries. Another, just very quickly, another good example is 529 accounts. A lot of them have that, right? 529 accounts for your children or grandchildren. And they are the beneficiary of the account, no problem about it. But when we do a division of asset, you cannot say, okay, neither side can touch this. This is my children's. No, it doesn't work that way. Even if the beneficiaries are your children, they're technically your accounts, your and your spouse accounts. So they can be divided. Most of the times when I deal with this, both parties are very reasonable. These funds are for children. We're not going to touch them. They can come to agreement. But if they cannot come to agreement, if one side insists a 529 account to be divided, it can be divided. It can be divided. So it's not children's asset. It's your asset.
Got it. Yeah, that's something that enlightening. Good. Yeah, because 529, we automatically think, those are the funds that stay for the children's education. Yeah. Wonderful. So yeah, it's a very, very good session, Helen. We really appreciate your time. We learn a lot. And then we definitely encourage everyone who attended the event today, or you have friends or other, like your children who would like to learn more about family law or prenup, please share with them the recording and the PowerPoint, the PDF file of this presentation, so that if they have any queries or follow-up questions, they can reach out to Helen directly. And again, we want to thank Helen for her time and also her generosity to allow us to enjoy 30 minutes of free consultation on particular cases, about the family situation. And so just name that you're a member of the GREI club and you have attended our event, like mentioned about Monica, then Helen would be very happy to help you on your queries. Thanks again, Helen.
No problem. Thank you, Monica, for providing me this amazing opportunity. I hope you learned a lot. And if you have any questions, feel free to reach out to me. You can actually, I can put my firm number here, so you can call my firm, and you can also email for any further follow-up questions.
Yeah. If you would please send me an email with the most appropriate contact, say your company, and then maybe we can set up through your secretary on appointments. And then when we send out a follow-up email that include the recording as well as the PDF presentation and your contact, then they would be able to reach out to you.
Sure. Okay, I will send everything to Monica and she will take care of the rest.
Yeah. Thanks again, Helen. Yeah.